Hello friends, in the series on income tax cases, today we will discuss a very important case, and this case is related to the deemed dividend provisions under section 2 clause 22 clause E. The provisions of section 2 clause 22 clause E is harsh in the sense that if a company gives an advance or a loan to a shareholder and the purpose of this advance is for the personal purposes of the shareholder, and if that shareholder is a substantial shareholder in that company, then even if that shareholder returns that money back to the company even in the same year, so the question was that whether in that case also the shareholder has to pay the tax on that as a deemed dividend. This issue has been decided by Honorable Bombay High Court in the case of J. Kumar B. Patil versus Joint Commissioner of Income Tax, and this case is reported in 486 ITR at page number 627, and the date of the judgment is 7th August 2025. The facts of the case are like this. In the present case, the company GPIL gave an advance to the assessee, who was the managing director of the company, and as well as he was also the substantial shareholder of the company. The assessee, which was the substantial shareholder and which was also the managing director of the company, was also running a proprietorship firm, and that proprietorship firm was supplying some material to the company, meaning thereby that the assessee was having the business transactions with the company and was having a running account with the company. The company was purchasing the goods from the shareholder and was making the payment to him. Apart from that payment, during the previous year, that is 94-95, that is relevant to the assessment year 95-96, some amount was given to the shareholder, and the purpose of that advance was that the shareholder want to pay his income tax, and the shareholder utilized that amount for the payment of the income tax. And at the same time, this fact was also very clear that the shareholder repaid the amount to the company in the same year. When the assessment proceedings were going on, the assessing officer issued a show cause notice to the assessee shareholder that why this amount should not be treated as a deemed dividend under section 2 clause 22 clause E. The assessee shareholder replied that I was having a running account with the company. There is no condition in section 2 clause 22 clause E that this money should have been utilized by the assessee shareholder for the business of the company. This was the contention of the assessee shareholder, and the third contention of the assessee shareholder was that this amount has been repaid in the same year, so the provisions of deemed dividend do not apply. But the assessing officer was not satisfied with the submissions of the assessee and said that repayment does not in any way spare the assessee from the clutches of provisions of section 2 clause 22 clause E. The assessment order of the assessing officer was duly upheld by the CIT appeal and by the tribunal also, and when the matter was before the High Court, the court said that in the present case the assessee has not utilized the advance for the execution of any job work of the company. The court said that assessee utilized the amount for the payment of his personal taxes, and if the assessee has repaid the amount to the company, that will also not make the case of the assessee better. The court said that mere maintenance of the running account is not sufficient to spare the assessee from the provisions of section 2 clause 22 clause E. The court said that assessee need not have to prove the business use of that money will lead to absurdity, because if that version of the assessee will be accepted, then the main purpose of introducing section 2 clause 22 clause E will be lost. The court said that maintenance of business relation with the company is also not sufficient because the amount has been utilized by the assessee for his payment of personal taxes. The court said that the ingredients of section 2 clause 22 clause E are all satisfied because the company do have the sufficient profit and loss account balance when this advance was given. At the end of this video, once again I am repeating the name of the case. The name of the case is J. Kumar B. Patil versus Joint Commissioner of Income Tax, and this case is reported in 486 ITR at page number 627, and the date of the judgment is 7th August 2025. Thank you, friends.